Good morning, everyone, and thank you for joining us today. In this webinar, we're going to explore with you the different types of dismissals and consider how the new day one right for claiming unfair dismissal that is proposed under the Employment Rights Bill will impact the avenues for claims. So we've got a lot to cover through today. And before we get going, we would like to introduce ourselves. I'm Victoria Templeton, the HR Knowledge Manager here at HR Solutions, and I'm joined today by Sue Watson. Sue is our Operations Director, and together we're going to guide you through today's topic. And we'll do that by inviting you to ask us your questions. We're aiming to answer as many as we can in the time we have. We have got a lot to cover through. So if there's anything that we don't get to, then we can follow up with you afterwards as well. On the screen now, you'll see an image of your, we'll put you on mute, but what we'll see now is on your GoToWebinar screen on what the panel looks like. Please type your questions and then we'll aim to read out as many as we can at the end. And we also like to make our webinars as engaging as possible, and we do that by using polls. These not only help steer the webinar, but it does allow us to share how the topic's being managed in our own workplaces. And so you can get a lot of ideas and thoughts from how other people on this webinar are dealing with things or their views on particular areas of the employment. So when you see this slide, we're going to be running the poll. They are confidential. We only publish the results. So we would welcome as many of you today to answer and take part in those polls. So let me just take you through what we're going to cover today. So I'm going to first clarify some of the current legal context position around employment tribunals, including the avenues for claims. I'm going to then explain how this area of employment will be impacted by the Employment Rights Bill, what the future looks like for us. And then I'm going to focus on why and how HR are essential for protecting the business and share our insights into some of the key risk management strategies available. And finally, we'll be letting you know where you can find resources to help you in the coming months, including details of a free in-person seminar that we're going to be running. So do look out for that. And then, as usual, we'll be taking your live Q&A at the end. Before we get going, we do want to run a couple of quick polls. It just helps put into context the makeup of the audience in terms of the organisations you're working in. So the first poll is about your organisation itself and how would you describe it? Are you a micro business, small, medium or large? Do let us know and it'll give us some context for going through today's topic.
Okay.
Thank you.
That one's launched now.
Okay.
I think it's a bit slow in loading this morning.
Is it?
Yeah, it's coming through now. Yeah. Thankfully it caught up. Okay, I'll close that poll and share the results. And so we have, there we go, 45% of you are in the medium 50 to 249 employees section.
Okay, yeah, that's good to know. Yeah, as we talk through the content. And so out of interest then, in your own organisations, who's responsible for human resource management? Obviously, we know it can land on the shoulders of many different roles. Business owner, office manager, or you may have your own in-house HR team or even outsource. Do let us know.
It's definitely sticky in loading. It's coming through now.
Okay, brilliant.
Apologies, I think there must be a go-to challenge this morning. Okay, we will close and share those results.
Let's see how that's broken down. Ah, okay. So majority of you have your own in-house HR teams or one individual, but actually other areas of the business do also take responsibilities, so business owners, office manager. I think it's going to be fair to say, so I'm sure you'll agree with me here, but the next 12 months, 24 months are going to be very hectic for those that have HR to deal with and work on. So hopefully taking you through today's session will give you some thoughts to help you planning ahead. So let's return to the webinar. And I'm just going to put some context around the topic just by talking through a little bit about employment tribunals. Obviously, this is such a wide discussion area. There's so many different aspects to it from a technical point of view, but obviously, clearly, I'm going to narrow it down to the key areas where that's the focus of today's webinar. The very first element is I've put here is ACAS early conciliation. So most of you hopefully all know that ACAS has a legal duty to conciliate in respect of legal proceedings, and in fact early conciliation is mandatory and places an obligation on a prospective claimant to contact ACAS. But actually we don't want to get to that point, so really the focus for employers must be on employee engagement, as actually employee engagement and getting that right is crucial for preventing your legal claims, because what that does, it fosters a positive, ethical and communicative work environment, and therefore helps to address issues internally before they then escalate into those formal legal disputes where you're getting ACAS involved and so on. And a disengaged workforce drives litigation because unhappy, disconnected employees, they are more likely to pursue legal action, like your unfair dismissal claims or discrimination claims. So I would really emphasise here that early employee engagement is a crucial aspect of human resource management. When you consider the costs of claims, then employers need to consider both direct and non-direct costs. You have the financial risks, such as your legal fees, the management time it takes to prepare, defend, compensation if you were to lose at the tribunal. But then also you have the non-financial risks, so that will be your reputational damage, the impact on team morale, you know, especially in the world of social media that we now operate, that's even more heightened. And for those of you that joined our last webinar, we spoke about average awards in tribunal claims. So we spoke in that particular one around discrimination cases. And we know that the highest award paid, for example, in sex discrimination amounted to £995,000. But even when you look at average figures, the average award from a sex discrimination perspective was still huge at £53,000. So costs is a massive consideration. And employers must also be aware that when someone is dismissed, employers can receive a claim anytime within a 3-month period from the effective date of termination. This time, this claim or the time limits for claims, or for most claims, will naturally then be extended by any early conciliation period. But also when you look at who can claim, this is going to generally depend on the issues at heart and the status of that individual. And so it's really important to understand the risk and avenues for claims as to what claims a person would have based on their status. Someone who's an employee has full employment protection rights, whereas someone who has a status of a worker has limited rights and avenues for a claim, as we'll come on to shortly. And this topic in itself warrants its own webinar, so we won't get into that as much today, but just to highlight how you can see where the employment protections lie based on employment status. So you'll see that actually it's really, really imperative that you accurately identify the true employment status of your workforce, because if you don't, if you get that bit wrong, then we have seen tribunal cases in recent years where a worker has challenged their status and they've ended up being successful in claiming that they are an employee and not a worker after all, and that obviously then leads to significant cost implications for employers. This slide here is to illustrate the various claims that are typical to the employment relationship. So the automatic unfair dismissal, we actually have written in legislation various dismissal reasons that if the dismissal was connected to it, it would make it automatically unfair. So you don't need any qualifying service to put that claim in. It automatically is unfair. There's no ability to justify anything. It is automatic unfair. You then have breach of contract claims, and that's where either party, it's not just the employee, but an employee can breach a contract, but it's when either party breaks condition or term of their contract of employment. You have what's called constructive dismissal, and that's where you've got circumstances that entitle the employee to resign and claim they've effectively been dismissed because their resignation was as a result of their employer's bad conduct. Discrimination, as I said, we spoke about this in last month's webinar. You know, that's where someone is treated unfairly, less favourably, or harassed because of a protected characteristic they hold. Your unfair dismissal, this is the area we're going to see significant change because of the Employment Rights Bill and what we'll come on to later in the session today. But currently, that's where the employee has to have those 2 years qualifying service in order to claim, first of all. But the dismissal was not for one of the 5 potential fair reasons, or the dismissal was unfair in the circumstances, and the decision to dismiss fell outside what would be considered as a reasonable response. So as I said, we're going to come on to that later because that's going to have a massive change as part of the bill. We then see unlawful deduction of wages, a failure to pay wages due under the contract, and like I said a moment ago, when somebody challenges their employment status, if they're citing that they've not been paid exactly what they're due, you know, you could see claims in that regard. You have a wrongful dismissal. That's where an employer terminates a contract in breach of its own terms, such as failing to protect or provide, the correct notice period or pay. So this is the current context in which we have to operate in. And I'll come on to share shortly how this is changing and particularly the significance of the change. So I mentioned a couple of slides ago the Sex Discrimination Awards, but actually here's the full table. So it's taken from the official statistics, looks at the period of April to June 2024, and like I said, you can see that sex discrimination had the highest maximum award payable, but you can also see other claims that were successful that also received significant payouts. And remember, discrimination claims are uncapped. So I thought I'd just share that context, and you've got the link there when the slides are published. But then you also have awards in respect of unfair dismissals. So bear this in mind when I come on to talking about the changes under the Employment Bill. So I don't know if you know, but when an employer loses at tribunal, then an award is made to the employee in respect of, first of all, a basic award. And that's generally calculated by the person's age and length of service. And here on the screen, you can see that the maximum basic award is capped at 21,570. And then you also have an element for, it's called the compensatory award. And that accounts for covering any loss of earnings, injury to feelings and things like that. And that's the cap of up to 101,900. So that's when you're dealing with unfair dismissal cases. Sometimes you might have a claim that is unfair dismissal and it has discrimination claims in as well. Remember, discrimination claims are uncapped, and so the context that I've sort of shared through here, these early slides, are really important to bear in mind because of the changes we're going to see in the next 12, 24 months. Naturally will have significant potential cost implications for employers. So now's a good point, I think, to just break and just ask some poll questions. And I said a moment ago how actually we don't want to get to the point of conciliating with ACAS. We actually want to be able to deal with issues ourselves as an organisation. And so we've got several polls now coming up. I don't know if it's a little bit slow again, but it's all to do with employee engagement. Employee engagement, as I've said, is crucial because it is It ensures that you have that motivated, engaged workforce, and you're less likely to see litigation and claims come up. So just out of interest, how often do you conduct, if you do, engagement surveys in your organisation? It'll be interesting for everybody here on the webinar to see what other organisations do and the frequency.
Okay, I will. There was a bit of a delay initially, but I'll just close up and share the results now.
Oh wow, that's brilliant! Actually, more than half of you carry them out annually or more often. That's really good to see, because as I said, it gives you that opportunity to pick up on any issues and nip them in the bud.
Absolutely.
Exit interviews are good. You could argue that perhaps could be too late. It's to what extent you can recover a situation, but definitely exit interviews are a good mechanism. Every 2 to 3 years. Yeah, thank you. And the next poll is around, we know the engaged workforce is crucial in preventing claims. What do you think is the most effective way an engaged workforce can prevent a claim from escalating?
That you might find it's more than one, but which is the most effective out of all of those?
Yeah. Well, the poll system is really sleepy, isn't it?
Really, yeah. Oh,
here we
it's
go.
coming through now. So once it starts, it seems to be quite quick at picking up, but there's a lag definitely in the results coming through. So apologies, everyone. Okay, I think most have voted now. I will close and share those results. There we go.
Yeah, absolutely. It builds employee loyalty, doesn't it?
Yeah.
And helps therefore prevent legal disputes. But it's really actually important to be using the internal grievance procedure. As I said, you want to be dealing with things internally. You don't want things to have to escalate externally. And then I think we've just got one more.
Yeah.
In here. So after today's webinar, if your organisation is going to focus on employee engagement, what do you think the priority will be for improving engagement and reducing the risk in your business? So there are many things that you can do. Oh, here we go.
You can see the delay when we comment on the responses finally coming through. Again, I think all of these are.
Yeah, you can do all of these things, but obviously what's going to be the priority?
Yeah, I'm going to close and share those results now. I think they've come through.
Oh, that's good. Yeah, so majority of you are focusing or will focus on improving internal communications. Absolutely, everything. I think communication is key to everything. And training, management training, absolutely. Training in handling difficult conversations is so valuable. Giving constructive feedback you know, all very important aspects of management training.
Yeah, and managing things from the start and from the outset of the employment relationship really well, so that the company's policies on induction and on engagement are implemented right at the start of the employment relationship. And some managers are better than others at that, and it's enabling them to have the tools they need to be able to effectively do that alongside business as usual, of course.
Yeah.
and carrying out their own role. Okay.
Yeah. Brilliant. Thank you. And I'm going to move on to actually now look at the future of tribunals and what's coming through from the Employment Tribunal, the Employment Rights Bill even, and it is going to be significant. If we remember that the bill has been introduced with the aim of restoring the principle that work should always pay. It's about creating job security, it's about treating workers fairly, and for workers to be paid a decent wage. That's the crux of the bill. And actually there's around 28 reforms all in all, but I'm only going to highlight those relevant to tribunals and what we're talking about today. I do have further information about how you can find out more about the other reforms later on, but let's just take you through what's ahead. First of all, it's going to begin with a couple of public consultations, because we know under the bill the government want to give workers protection from claiming unfair dismissal from day one of employment. So what I said earlier on, in that you have to have your 2-year service, the government want to abolish that and make it a day one employment right. And therefore what follows on is that the government will introduce a statutory probation period. It's also known as initial period of employment. And we need to have a public consultation take place to understand the views from businesses, unions, professional bodies, to understand what this probation period could look like, how it could work in light of the unfair dismissal being a day one right, and what it effectively will mean for employers, you know, particularly from having any lighter touch procedure for managing dismissals in those early months. We do know that this unfair dismissal day one right, or the statutory probation period rather, will not apply in redundancy situations, which complicates things, because there's two legal contexts we're going to have to be aware of when managing dismissals. But effectively, we're going to see any time now, I think, public consultations open to feedback. And as an organisation, we ourselves contribute into those public consultations, so we get to have our say on behalf of many, many organisations, and obviously you're able to as well. These areas are probably the biggest in respect of the entire Employment Rights Bill, and they will present several issues that I'm going to expand on in a moment. The second box here is around, we're going to see the introduction of a new enforcement body known as the Fair Work Agency. Whilst it's expected to be established from April next year, it's going to have a gradual implementation, because this is going to be massive. It's going to be a body that will have enforcement powers to ensure fairness, and that employers are giving their workers their full employment rights. And interestingly, this enforcement body, the Fair Work Agency, will be able to bring tribunal claims on behalf of an employee, even if they weren't planning or wanting to do so. So it's going to have a lot of power to it. And as I said, its aim is to focus on making sure employers are complying with their legal obligations. We're also going to see the time limits in which to bring a tribunal claim extend to 6 months. So remember at the outset I explained at the moment there's generally 3 months in which to bring a claim. This is going to be doubled. The current 2-year qualifying period for claiming unfair dismissal that I spoke about, that's going to be abolished, but from 2027. So we've got a period of time, but there's going to be, as I said, the public consultation, and then we're going to need to see regulations and secondary legislation drafted. And the regulations that will then be published will give us the guidance. I say guidance, it will give us some information as to how we expect tribunals to be ensuring that unfair dismissal piece works from day one. And to support that reform, we need a new statutory probation period. And that is also going to be introduced at the same time from 2027. And as I said, that's also known as the initial period of employment. And what we know from publications and announcements from the government, we expect this to be a 9-month period. So in that 9-month period, there'll be a relaxed approach to a shortened, I guess, process to how you end dismissals, but there still has to be that fairness, because essentially they'll still be able to claim unfair dismissal. And finally, very recently, you may have seen in the press that we're likely to see the return of tribunal fees. This has been in the news for the last few years, actually, but it's come up again. And I think we're not likely to see the levels of fees that we've previously had, because clearly it was ruled by the Supreme Court to be illegal, because ultimately it prevented people from seeking justice. But there's an acknowledgement in the government that actually there needs to be some fee associated to submitting a tribunal, simply for the administration that goes on in the court system for processing claims. So that is on the horizon. It's not necessarily set out in the Employment Rights Bill, but I just thought I'd flag it now because it's obviously relevant. So what will this mean? There is a lot to consider as an employer. So we are unfortunately going to see a higher, greater risk from getting tribunal claims, even having a lighter touch procedure during that initial period of employment. A day one right to unfair dismissal means all new employees can bring that tribunal claim from the start. So it significantly increases the potential for litigation and the associated costs that I've mentioned. So if you remembered that slide that I said there's a basic award and compensatory award, it means that there's scope for all employees to put a claim in and potentially have compensation and damages as a result. It actually can possibly discourage recruitment. So particularly those of you that operate in small to medium-sized organisations that do have that limited HR resource, it might mean that you become more cautious and risk-averse in your hiring practices. It might be that there's less willing to take a chance on a candidate who isn't quite the perfect fit from the outset, so potentially limiting opportunities for those re-entering the workforce or those requiring more on-the-job training, perhaps. It's also going to bring a need for formal processes from day one. So the proposed statutory probation period, this initial period of employment, aims for a lighter touch dismissal process, which is likely to have a meeting right to be accompanied and a written outcome as a minimum, but it still mandates a formal documented procedure. So this is a significant change from the current system, because as it stands at the moment, as some of you may know, but where there's short service dismissals, it often requires, not much of a formal procedure beyond the contractual piece that you need to honour, like your notice periods and things like that, provided the dismissal isn't, of course, for any of the automatic unfair reasons or any discriminatory reasons. But this reform in this area will mean that there's going to be a need for formal processes from day one. Training and consistency of policies are going to be crucial. Employers will need to immediately train their managers on the new lighter touch procedures, ensure that the procedures are applied fairly and consistently across the organisation, and any failure to follow the prescribed steps, even during probation, could lead to a finding of an unfair dismissal. So as I'm talking, it probably sounds, it's probably highlighting the significance of this reform, like I said a moment ago. This is one of the biggest aspects of the Employment Rights Bill. There may also be some confusion between the statutory initial period of employment and any contractual probation period. So what if, for example, I mean, I don't know if this is probably a realistic example, but say you've got a 12-month probation period because it's a very senior role, it's probably a complex role, but actually the new statutory initial period of employment is 9 months. How does that sit? How does that work? So it's going to take some careful alignment of your policies and contracts of employment. In terms of assessing new starters, you're going to have a shorter window for assessment. So whilst a longer statutory probation period, like the 9 months that they're proposing, is helpful, like I said a second ago, it may be you have complex or senior roles in your organisation that genuinely take longer than this 9 months to be able to fully assess the suitability, cultural fit, or even long-term performance. So it'll be interesting to see how this all pans out in reality, in practice. And when we think about documentation, to fairly dismiss an employee during the initial period of employment for reasons like your conduct, your capability, you're going to need to show that you have sufficient grounds, you hold that genuine belief for why you're dismissing that person. And so that necessitates a rigorous, well-documented performance reviews, feedback, and record issues right from the start, placing that immediate administrative burden on the employer and line managers from the go. Now, I did mention that there's some redundancy exclusions. It is anticipated that the lighter touch procedure will not apply to redundancy dismissals. So it will mean employers will still have to follow the full complex unfair dismissal rules from day one. So it's got that two-stage approach. It has to meet one of the reasons set out in law, but then it also has to be fair and reasonable and be a reasonable response. And so that becomes a logistical and legal challenge when you're having to have that mindset and to remember the legal ramifications and the framework that you're operating in. So I think in summary, the reform is going to force employers to adopt a more formal, legally rigorous approach to all dismissals, particularly for the new hires, and it's going to shift the risk of procedural burden from the employee's 2-year anniversary to the first day of employment. But it's also going to mean that there's going to be a longer period of liability, meaning that employers will have to now wait 6 months after somebody's left the organisation to see if there's a claim going to be submitted and be on standby. You'll be on tender hooks to know if you're going to get that claim, and it could be you get it in at the 11th hour. If we think about data subject access request processes, we could see this reform impact on that in terms of how and the timing in which a claim is submitted by the employee. So at the moment, we have that general 3-month window for somebody to put a claim in. But there could be situations where they have to submit it before having fully completed any data subject access requests. You know, if a request is particularly complicated, complex, the organisation needs some reasonable time to actually carry out that search, the employee at the moment has to still meet that 3-month window. But what this reform is doing is they're giving them 6 months, to put a claim in. And so there's more chance that they'll have that data subject request fully completed and the data with them before that 6 months is up. And therefore, they've got all that information to help construct their what's known as the ET1, their official claim form, which is a crucial document for how that claim then progresses. The ability to apply an abridged dismissal policy at the moment will be lost. It's common for shortened processes to be offered where the employee has less than 2 years service. As I said, you don't need to demonstrate fairness in how you dismiss, however hard that might be from an ethical point of view. You can dismiss for any silly reason, as long as obviously assuming there's no discriminatory or automatic unfair reasons. But put it bluntly, if you haven't got your 2 years, you can't put a claim in. So the ability to operate short service dismissals will be gone. Employment practices and therefore documentation is going to become outdated. The introduction of new employment processes will lead to greater admin and that burden for employers, especially as there will be a greater burden and obligation for thorough record keeping from the outset. So there was a lot going on. This is the biggest, as I say, reform under the bill. I'll invite Sue to sort of come in and discuss her thoughts and views on this as we work through the polls. So I've got 2 or 3 polls now to do with this area. Be interested to know what you're feeling, your thoughts on this particular topic. So Sue, if you could open up the first poll. And it's really getting an understanding from everybody, if it's awake. You know, what's your greatest concern for your business, this whole change in ordinary unfair dismissal becoming a day one right?
I think while we recognise there may be more than one concern,
yeah,
what's going to have the biggest significant impact on you, do you think?
Well, I might get you to answer this question then, Sue, from with your operational hat on. Or what you're hearing from clients or queries or getting through.
Yeah, I think it's where the poll's kind of going. Actually, for me, it's the difficulty dismissing in probation when they're not suitable. Not that it happens very often if you get your recruitment right, but it's particularly if I look across our clients as well as our own experience, sometimes things are not working out for whatever reason, whatever good reason, and the shorter dismissal processes are helpful. Because it could be damaging for the business to sustain somebody in a role, and the formality of processes are not always very, very practical. So I do think it's going to give us all challenges. I'm going to close and share the results of this one.
Yeah. Be interesting to see.
I think everybody's feeling the same.
Yeah, probation, absolutely. The probation's coming up the top. Because you've got, I mean, you've got the flexibility now, haven't you? Like you say, having, you'd have a genuine reason why something it's not working out, and you've got that ability to manage in line with business needs. And if you need to end somebody's probation, you end it, and you're not carrying particularly high risk. Of course, let's, for the purpose of today, put aside discrimination and automatic unfair dismissal issues. So yeah, I guess it kind of takes away that flexibility and that ability to manage and run your business.
Yeah, and I think the second highest one there, the high risk of claims, we're already seeing a significant increase in claims across the UK. This is not just us, clients, receiving claims. Our client experience, it's gone up 200% in the last 12 months in terms of the numbers of claims being received, and they are, thankfully, the majority are ill conceived and are unlikely to succeed. But and I think there'll just be more and more of it as they reduce the sort of management powers to sort of deal with these things in the most effective way for their business. But obviously everything we do, you can't prevent a claim coming through, but you do everything you can to put yourself in a good place so that you can close it down quickly, hopefully, and it doesn't get, it gets thrown out. But it's going to be interesting times ahead.
It is, and the interesting thing for me is how the court system will handle the increases. And I don't know if you've seen recently, Sue, there's been some advertising for panel members, tribunal panel members to appoint, and that's in preparation for this, because I think even the government themselves acknowledge and see that actually there's going to be an influx of claims, and even now there's a backlog, isn't there? So it'll be interesting how it unfolds, but also with all the press that this bill is getting, people are going to see, oh, I can claim unfair dismissal, and even if there's not necessarily a case, they might feel or have the perception that something's been unfair doesn't necessarily mean to say it has been legally unfair. So quite interesting. Thank you for that. And then the second poll is around this statutory probation period, or what we call as initial period of employment. I don't know if any of you here on the webinar operate an existing probation policy that's perhaps contractual. So this is more about trying to get your thoughts on how it will impact your current position.
Yeah, sorry, I've been loading them a bit early at the moment, just because it takes so long for them to come through.
That's okay. Good thinking.
I mean, for those of you who have been in the business as long as I have, might remember the statutory dismissal procedures that we had in a previous government, and how challenging that was to implement. And that was not quite as, it wasn't a day one, right, but it was 12 months, and they didn't impact the statutory probationary period, they introduced a statutory probation period, and I'm just thinking it's like going back to that, but worse. And we were all mightily relieved when they went back to the 2-year and giving us all that flexibility. So yeah, it's right, I'm going to close and share these results.
Okay, let's see.
So
okay, 47 will have to lengthen the existing policy to match. Yeah, there's going to be some care and thought needed to work out how your policy needs to align, so it works for you but also complies.
Yeah, I think the significant majority probably have a 6-month, 3 or a 6 months probation period, depending on the roles. 9 months is a long time. I was surprised when they were suggested 9. I thought they might have done 6, but I assume it's because of having to accommodate the statutory probation period and the processes that will be required in order to work through that and give appropriate time for those more kind of impactful processes,
isn't it?
Yeah,
because if you've got a probation period that's 6 months, but you also allow extensions to probation periods that's taking you up to that 9-month mark, it's getting your head around how that all operates with legal risk.
Absolutely. Right, I think we've got one more, haven't we? Here?
One more, and then we'll move on. I am looking at time, so if we do overrun after 11 o'clock, please do bear with us and stay with us if you can, because we've got lots of interesting stuff to cover. But I'll get through it hopefully as quick as I can. So this poll is about the area in your business that you think most urgently needs a review or update in light of these legal changes. So pick one that's the most urgent or top priority for you.
Oh, it's landed.
Don't know what's going on with it today.
We have had notification of a go-to maintenance program. I think it's this weekend. Maybe this is part of it.
Gosh, yeah. Wouldn't that be, oh gosh, nightmare if it was Thursday, 10 o'clock till 2 o'clock or something.
Yeah, this is over the weekend.
So let's see. So this is the most important area for you now, bearing in mind this change to the unfair dismissal role.
Okay, I'll close and share those results.
Ah, yes, interesting, good. Definitely, management training, you know, because actually they're the ones having to put in place the legal obligation, they apply the legal policy or framework. So training your managers is fundamental.
It's the highest risk area as well for a business. Your managers are your highest risk if they don't follow, and if they've not been made aware of the significant changes, especially those who there are still managers who make instant dismissals on the spot when they get frustration, get too much. You know, it still happens, but you know, that's more high risk now than it ever was before. So and it's going to take a while. For some organisations, it's going to take a while to update their policies and then get the training, appropriate training identified, roll that out, and then support them with it as they come through. So let's hope everything goes smoothly for everybody.
I know, this is what I keep saying, it's the biggest challenge of the whole bill. I mean, and don't forget, you've got probably 27 other reforms as well on top of these.
Yes.
It's mind-boggling. But let's continue, because just quickly on this slide, I'm not going to go through it. You've got a QR code there that will take you to the roadmap. But we're running a seminar, it's free, later this month. I've got some further information later on where we're going to go through this in more detail. But we've got this roadmap. It's based on the government's announcement of a couple of months back, but it gives us the timeline of what is going to happen when, which is key. And that's what's driving our work, our focus, our priorities. So do check out that roadmap and download it. And of course, I'll come on to talking about our seminar event that we're running to support that roadmap. So before we get to Q&As, obviously a significant part is looking at how essential HR practices are for protecting your business and risk management. So I want to spend some time around that. And risk management is all about, first of all, identifying your risk, carrying out that analysis or the assessment, working out risk strategies, making sure you implement, and then what you implement, you need to be monitoring and reviewing it and making changes as you need. But you must also partner with your HR team. HR is more than a departmental function. It's actually an essential component to risk management, because the single greatest risk to any organisation, as awful as it sounds, it lies in its people and the processes surrounding that. HR's role has evolved from purely transactional to becoming a strategic function that is the primary guardian, if you like, against legal, financial and reputational harm stemming from the workforce. And the whole HR risk management is a systematic process. Like I say, it's about identifying, assessing, mitigating risks, and then using that to actually put in place the right strategic plan. The workforce itself is obviously both the most valuable asset and the biggest potential liability for a company. And I'm going to sort of explain and expand on that. So HR's role has evolved purely from that transactional to strategic function. We know people are a source of risk. Most organisational risks, data breaches, fraud, workplace violence, conduct, etc., are either committed by or involving employees. HR manages that entire life cycle of the employee, from hiring to separation and leaving. These are the areas where most risks emerge. Compliance and legal liability is crucial. HR is your front line for ensuring adherence to a complex and ever-changing world of employment law. Non-compliance in employment law leads directly, as you know, to what I've just talked through. So your fines, penalties, lawsuits, reputational damage, etc. HR's practices in handling employee relations, discrimination and conflict directly therefore shape the company's culture and external reputation. So mishandled issues can lead to highly valuable public disputes that can severely damage the brand and ability to attract. So you need HR's role in mitigating all these risks associated to the reputational damage, the legal liability, etc. Focusing on effective HR practices will then allow the business to move from being reactive, only addressing a problem after a costly event occurs, to becoming proactive, where it's about building systems, building a culture that prevents risk in the first place. And we talked about employee engagement early on. That is fundamental to the employment relationship, and HR can help foster that employee engagement. But let's just think about some of the practical, essential HR practices that can help your organisation and its primary line of defence. So, as I said, it's about becoming proactive, building systems and that culture to prevent risks. And it begins with employee engagement. this is crucial, because if there are issues within your workforce that you've identified, but they're not being picked up on, issues just escalate. It becomes bigger and bigger, and then it comes to a point where unmanageable, and that's not what we want. We want to be dealing with employee engagement. We have things like risk audits. Risk audits systematically reviews your existing working practices, starting from recruitment all the way through to termination, and it helps you to identify potential areas of non-compliance with employment law. It helps the organisation to pinpoint vulnerabilities. Perhaps there might be some inconsistent application of policies. There could be some unfair practices, discriminatory practices happening. So it allows for the organisation to carry out that corrective action before anything escalates into a legal claim. And I'll come on shortly to sharing with you where you can access our online free tool for carrying out a risk audit too. And then we also have ongoing tailored training, and that is essential, not just for managers, but for employees as well, on aspects of employment law. Equality, diversity and inclusion, managing probation, managing performance, absence management. Training ensures that everyone understands their legal obligations, what the company's expectations are, and it reduces the risk of unintentional policy breaches. And then in the event of a claim where you can evidence that there's been comprehensive training and that you've taken reasonable steps to prevent any issues, that strengthens your defence. And in recent years, what's really important to bear in mind that we have had case rulings that have been critical of an organisation's lack in frequency in which they train. So it's not good enough, if you like, to just do a one-off training event. It has to be ongoing. It can't become outdated or stale and stagnant. You've got to be training your managers and employees, but do so on a regular basis. And that's what builds your defence for when you're defending a claim. And then another core defence is about having robust contracts, employment policies and handbooks as well. You know, having these robust documents that are legally compliant, clearly communicated, is going to be fundamental, because they set out the rights and responsibilities, not just of the employer, but of the employee, providing that clear framework for the employment relationship. So they serve as a primary defence against claims, and they can be used to prove that a specific action was in line with an established company policy, such as your discipline procedure, performance management processes. And again, these aren't documents that once created are then just left. They need to be under review. They should be monitored and updated in line with what's going on in your organisation and legal compliance as well. We then are going to see some changes from a harassment point of view, from managing third-party relationships. So I thought I'd flag this here. So when working with contractors, freelancers, temp agencies, these are third parties, and we're going to see the law change around employers having an obligation to prevent harassment from occurring from third-party relationships. So that's why having those clear contracts in place are imperative, and preventing liability for the actions of a third party. So that's something that's really important to bear in mind, preparing for how that reform will come in. Monitoring of key employment metrics, such as your disciplinary cases, what actions you've taken over the last 12 months, what grievance cases you've had, what outcomes have you given, what promotions have occurred, what are the pay scales. All of that data helps you to identify patterns or disparities that can indicate a systemic issue, such as, for example, unconscious bias, or problematic areas where perhaps it might home into an area that perhaps needs further training. So there might be team leaders that may be new to an area of the business that then need training. Then there's also the importance of open, transparent communication, because that builds trust, and it came up in one of our polls earlier as one of the highest results. It builds trust, it reduces misunderstandings. These are all things that can lead to dispute if you've not got it right. So keeping employees informed about your policies, your expectations, in a clear, accessible manner minimises any risk of claim or disgruntled employees that can then escalate into serious issues. And as I said previously, documented communication can also serve as evidence in a tribunal, demonstrated that you have acted reasonably and fairly. Conflict resolution is significant. I've spoken quite a bit about employee engagement, nipping things in the bud. Managers need to be able to handle difficult conversations. Having effective conflict resolution processes, not just your formal grievance procedures, but things like allowing mediation to take place, informal or formal, having various methods or mechanisms in which somebody can go to somebody to raise concerns, informally, formally. These are all vital to a healthy relationship that aims to tackle and reduce conflict in the workplace. And then finally, and I may be biased as a HR professional, but I can't tell you how vital it is to seek out early HR engagement and advice when you're managing situations, or even before a situation occurs, but you can see there's probably signs of some unrest, or somebody might be disgruntled, or there might be an issue bubbling. Seeking that early, ongoing, and getting ongoing HR advice is crucial, because it ensures that all actions can be taken from the moment that potential dispute arises, and that you take legally sound and well documented advice. And that again helps you to build a strong defence, because if you're showing a tribunal that you sought help and advice from HR, that puts you in good stead in terms of you've wanted to try to carry out all the actions you've needed to try and deal with the situation. You haven't tried to bury your head under the sand kind of attitude. In fact, it's more important to work alongside your HR teams every day before even any issue arises, because that's where it can help you to look out for things, spot things early, and to therefore, like I say, nip things in the bud. So I'm going to pass to Sue for a couple of more polls, give my voice a little bit of a rest. And this is about costs and tribunal risks.
Sorry, I went for launching it first. just to give it a chance to catch up.
Okay, brilliant.
So this first poll is around the most significant and impactful to the business in terms of the costs and the risks. So we're looking at a couple of things. This first one on cost, and the second one we'll look at is risk. The responses are coming through now, so that's good.
Oh, good.
Okay, let's close and share those results. So the legal fees, yeah, particularly in the SME sector, which is a significant majority of you all are, that is potentially going to be the, because even if you have a robust defence, even if it's a spurious claim, you've still got to spend the time of submitting the response, or of trying to settle to make it go away, submitting the response to the tribunal, preparing witness statements. All of this takes an inordinate amount of time to pull everything together, pulling all the documents together. And if you are if you don't have the capacity yourself, you've got to pay somebody else to do it. And so the costs there, even if you've done nothing wrong. So, you know, it is definitely going to be, I think, the biggest for a lot of people. And the reputation, tribunals are public. So
but yeah, I was just about to say that.
Yeah, and if you get lots of claims in one company, or even more than one, then it starts to become, can affect your recruitment, because people think, oh, why are they leaving? Even if they're leaving for good reason, for a defendable reason, from the employer perspective. So, yeah.
Interesting, yeah.
Absolutely. Shall I put the next one up?
Brilliant.
Yeah, which is about the risk element. So we're looking at risk now as opposed to cost. What factor do you believe is the single biggest contributor to legal claims?
Gosh, they're all valid.
They are. It's just the biggest one, I guess, that's impact. So for those where it hasn't landed yet, it's a lack of clear policies, poor training with managers, low engagement, workplace harassment, bullying, or retaliation following a complaint.
And all this feedback's actually really good. It's got me thinking about my focus areas for webinars coming up, what we can do, what we can offer. So it'd be good. Thank you for your responses in these polls. And do let us know. Just drop me a message separately if there's any particular content that you want, that you think would be useful for next year's webinar schedule.
Okay, let me close and share that result. So there we go. So poor training, I think absolutely. They're your highest risk. They're the front line, aren't they? The ones. And you might not always know. That's the thing. If you're responsible, particularly if you're in HR, you don't know what's going on in that team, in the business, and all of a sudden it comes across your desk when it's got a little bit too far. That's kind of when we're often called. I didn't know about this, but and it's always harder to manage after the event than it is to have managed it all the way through, to have given you the best possible sort of audit trail and ability to deal with it informally, to resolve it hopefully before it gets to something that's they're considering taking it to tribunal. So the aim should always be that managers nip everything in the bud. Victoria, you mentioned that earlier. Deal with it on the spot, but deal with it appropriately and try and resolve it. Try and resolve it with supportive, considered responses, so that you hopefully can resolve it. Doesn't always work, but having the policies in place to support you, so the manager's got something to refer to, got something that clearly demonstrates where perhaps an employee hasn't been following the company line. It just gives you something to manage against, as opposed to them thinking, well, it's just you being my manager, and that can cause all sorts of other issues. And we all get the ones where you're trying to manage someone and they raise a grievance. I mean, it still happens, and people struggle anyway with sometimes with receiving that news that you're not happy with their performance, and so that's still there as an option, isn't it? Okay, shall I hide those now?
Yeah, lovely. Thank you.
There you go.
So I've got a few slides before we get to questions, if we've got time for questions. I mentioned that we're running a seminar. It's free to attend. Anybody that's local to Coventry, we're It's taking place at Coventry Building Society Arena at the end of October, and that's where Sue and I are going to lead you through. It's a 2-hour seminar of the Employment Rights Bill. So if you remember that roadmap that I highlighted earlier on, we're going to be talking about that in depth, give you our take on it, how we feel it could impact the business or is likely to impact the business, and then talk through some of the things that organisations can be doing to mitigate and prepare for the changes ahead, because it's going to be significant. So we'll give you some practical steps there and give you our insights. So do check out the event. It is live on our website. As I said, it is free to come along. So it'd be great to see you there and to actually meet you in person, because I know we have regulars come to our webinars. So do come along. There's a QR code there. Should take you to the landing page for our free event there. And then actually, if you want to try us out and get some free advice, we're offering a free 30-minute consultation with one of our experienced members of staff in our HR advisor team. So it could be you're dealing with performance issues, you could be dealing with absence, or you're wanting to strive to create a workplace culture that then prevents workplace disputes like we've just been talking. So you can try us out. So you simply go to the QR code there. It's available on our website that takes you to all the contact details, and we'll be more than happy to talk through your situation in that half-hour consultation. I've mentioned risk audits. These are critical. Now is a good point in time to actually see how your business lies with compliance. So get yourself ready, get all your everything lined up. So there's a QR code again. It takes 10-15 minutes to complete. As I said, it's free, and you'll get a report at the end of it summarising our responses and giving you some recommendations on the back of it. So do check that out, and it'll help you now in starting to think about preparing the business and getting things right. We also offer some impact assessment templates in readiness for the Employment Rights Bill. So they take a particular reform and it asks you a whole range of questions to do with all aspects of your business, because employees need to think not just about HR implications, but actually the wider implications of the reforms on the entire business. So the way we've developed these assessments, it guides you through many different areas, from sales, marketing, finance, budgets, you name it, people, to get you thinking about how each of the reform impacts that element. Before we take your questions, I've got a couple of quick polls. So Sue, if you wouldn't mind just calling up these quick polls, and then we'll take your questions in the last remaining moments. I know we've overrun slightly, but if everybody's happy to hang around, it'd be great if you can stay with us. Yeah,
we've got a couple of questions that we can discuss shortly. Yep. Just to say that the one or two where the slides went too quick for the QR codes, you will get a copy of the access to the website. Sorry, to a link on the website where there will be a copy of the slides and a recording, so you'll have plenty of opportunity to either use the hard copy or freeze your screen and access all the QR codes then. The one for the event and the seminar link, so the events one is currently just being updated, so it should be available this afternoon. We're just adding a couple more into that that we're about to announce, so that will be shortly available. So that just deals with the sum, and then I'll just close that one and launch the next one.
Yeah, sorry, I just took it back to that slide while you were doing your poll.
Yeah, and so this is just in case any of you want us to contact you after, just let us know. And then we've got a couple of questions that we'll discuss, and then we've got some more information on our forthcoming webinars. And this, okay.
Yep.
I will.
If you should we go to questions? I've just got the
Yeah.
slide showing now of the.
Okay.
Here we go.
There you go. Yeah. Sorry.
The systems are really slow. So
Yeah.
sorry if I whizzed through that slide. So there's a QR code for you. And we'll start taking your questions now.
Yeah. So the first question, so this is around whether the new unfair dismissal laws are going to apply to workers and employees or just employees. I think one of the biggest challenge there is, are your workers generally workers? And quite often, ones you believe are workers will raise a claim claiming they are actually an employee. So you have the whole status thing to debate as part of the claim, because it could have implications for what they are able to claim. So workers can claim if they haven't been given, if they're not given sufficient holidays, sick pay, if they're entitled to them. So again, it depends. They can definitely bring a claim if they believe they've not been fairly compensated for those. And again, a lot of people we find that are workers try and claim that they're actually employees because of the regularity of the hours, the fact that the the organisation has control over what they do and how much they do, and provides everything for them, includes them as part of the team. You know, it's definitely it's definitely a bit of those grey areas that can end up getting really messy. So it could.
And we've seen lots of cases in the last 2-3 years about employment status, successful cases, whether it's Pimlico Plumbers is one of them. You've got Uber, and that's all centred around holiday pay. But interestingly, the government, whilst it's not part of the Employment Rights Bill, we know that the government are keen on having two types of employment status. So what that is meaning is at some point in the future, the government would like to aim towards having self-employed is one employment status, and then worker is the other. So actually in the future, we might just have one type of employment status for employees and workers.
Yeah.
That's where I think, I think that's where it's going. It's not in the bill at the moment, so it's not on one of the 28 reforms, but I think that's where it's heading.
Yeah. So yeah, I think the answer is yes, potentially.
Potentially, and we do need further regulations on this reform to see how it will work. Yeah.
And so the next interesting query was around, do we see a potential trend in more fixed term contracts, particularly for senior or technical roles or key expertise? I think the challenge with fixed term contracts, as always, as is now, is that when you come to terminate it, is the work continuing? So is it genuinely a fixed term contract, and why are you making it a fixed term? You can't do it to avoid legislation or to avoid a legal challenge if you employ them for longer. So I think you could end up with unfair dismissal claims more easily if you're not careful. You need to justify even more.
From what I've been reading in the bill in general, when you read a lot of the papers that sets out the proposal and the rationale for things, it is generally getting picked up that the government are aware that it shouldn't lead to unintentional consequences, and this is probably an area where that could be an unintentional consequence, in that employers don't hire on permanent open-ended contracts but instead hire fixed. So I reckon, and this is all just me, my own view, so please don't quote me, anybody. My thoughts are is that when we see we've got public consultation that's going to happen, so that's the starting point for employers to feed back, and then we're going to see draft regulations and codes of practice. So I wouldn't be surprised if we see something within the regulations that closes any loophole that means employers can use a fixed term contract as a way of avoiding unfair dismissal and things like that.
Yeah, absolutely. So maybe one more, shall we do? And then I think we'll have to come back to you with maybe there's a couple more that are, oh, there's a few more coming in now. We'll perhaps have to just do a Q&A response for you that we send out afterwards, or update, or include it in a future webinar, depending on the topics. There's some questions around when to implement all of this. So if they're reviewing policies now, should they update it now, or should they? They've currently got really robust processes. So do you think there's anything else they need to do now? And you know, I guess it's both sides of it. You know.
Yeah, my suggestion is to start looking at your impact assessments. And it's thinking about each of the reforms, and we'll cover this on our seminar later in the month, but it's about thinking about the impact of each of the reforms. But if you focus on this one, what does it mean to all aspects of your organisation if this was to come in? And I think now is a time for your, like, the thinking phase, your planning and preparing. There's not so much you can necessarily do in terms of paperwork immediately. That will probably come later this year once we've got some feedback from the consultation. So I suspect once that consultation is closed and we see the government response, we'll have a better idea as to how things are going to be designed. And therefore, I'd say early next year, end of this year, we could probably start thinking about what policies look like. But certainly now is your planning in terms of, I guess, identifying what practices currently exist and what practices will likely need to be reviewed and updated.
Yeah, I think if
get yourself organised in that respect.
If you've got good training in place for your managers anyway, it's alerting them, making them aware that things are changing. Start to think about how you manage. Start to, you know, build in those more robust processes. You might not want to formalise them yet, but just make your managers think about it and say, you know, very soon we'll have to formalise all of this and change all our policies and processes. But I want you to just consider.
Actually, one thing now is for actually organisations that don't already have probation periods at all, start thinking about developing a probation process. You know, the headlines and that it expects to be 9 months, but you know, certainly there'll be a need for a meeting, a letter, right to representation. You could start by putting in place a probation policy.
And looking at the ACAS code, I'm sure that'll be where they will drive the change. They'll be updating the code, and with the new initial probationary periods that they're introducing. So we obviously await more detail for a lot of this ourselves, and as soon as we've got any concrete information, then we will be updating all of our templates anyway. So we kind of got everything on watch at the moment. As changes come in, we're trying to let everybody know, and trying to support everybody as much as we can, with you know, the essentials to help you get going. So
thank you.
I think that's it. Thank you.
Okay, I'll have a look at any of the remaining questions, and I'll probably do an FAQ afterwards so we can send out. For those of you that join our webinars, here is the schedule that's coming up. If you're new to our webinars, we run them monthly. So these are the topic ideas. The updated schedule that we're showing here will be live on the website later today, early tomorrow, as well as on our knowledge base as well. So do join us for our future webinars. Do keep in touch with us, especially at the moment in the lead up to the bill as it's going through its final stages, and finding out about the latest news. So do keep in touch with us. This is how you can do that. It'd be great to have you follow us on socials, and get in touch and follow us. So thank you, everybody. Thank you for your extended time. I know everybody's really busy. Thank you, Sue, for your assistance in the polls and the conversation. It's been really interesting. It's been great to sort of talk this through with you all, and we hope to see you next month on our webinar. So thank you, everybody.